What's up, everybody? We are checking back in on Gabby Petito's parents' lawsuit against Brian Laundrie's parents, plus some other parties. But today, those are the parties we are going to focus on as we are going to discuss this burn after reading letter drafted by Roberta Laundrie to Brian Laundrie. We've heard a lot about it. We haven't seen the letter. We've heard of some of the contents of the letter. But today, we're going to discuss how the Petito family officially asked for this letter as part of discovery. They're arguing it is discoverable. The Laundrie family has objected, and they have filed a motion for a protective order. And we get some details surrounding that letter. We'll talk a little bit about what Pat Riley, the Petito family lawyer, says about this letter. And we will talk about whether or not we think it is going to be something that is discoverable in this case. If you are still following this Petito case, we told you the litigation is going to be long. There's going to be a lot of fights. There's going to be a lot of fights over discovery. There's going to be motions to dismiss, which has been filed already by the Laundrie family attorney, Steve Bertolino. So we'll continue to follow this case as long as you all are interested in it. So let me know if you're still interested by commenting below, letting me know, and liking this video. And if you're new to our channel because of this case, go ahead and hit that subscribe button because there will be more as long as the interest is there, as with any content on this channel. If you guys have questions that I can answer and explain how this process works, that's the goal of this channel. So this is a letter that was first mentioned by Pat Riley, the attorney for the Petito family, when they went to law enforcement headquarters to talk about where certain evidence will go when the evidence was released. This was a letter that was at least looked at by Pat Riley, but he said that when Bertolino took it, and the family, the Laundrie family got it as part of their possessions, he was told this would be handed over in discovery, so you'll be able to look through it in more detail. And now that they've requested it, it has been denied. And they are trying to keep this letter from the Petito family. Pat Riley has said that he remembers in this letter discussion of a shovel burying a body and other statements that would lead you to believe Roberta Laundrie and the Laundrie parents knew what happened to Gabby Petito, which is part of the nexus for this lawsuit on what they did or didn't do during the search for Gabby Petito, the statements that they made or didn't make, and how this lawsuit is pending because of those statements and because of their actions or inactions. So this was a big part in proving what exactly they knew. Now, in a recent interview with JB Bueno on WFLA 8, Pat Riley said that he does not remember seeing a date in this letter, which is one of the points of contention, is when was this letter actually written? Does it have anything to do with Gabby Petito or this case? And secondly, he said he does not remember seeing Gabby Petito's name specifically in this letter. Now, he doesn't say that means it wasn't in there. I would be willing to guess if it was in there, he absolutely would have told us. But in fairness to him, he did not read every word of this letter. He just scanned it, which is why you want it in discovery. And why he would reasonably expect it to come through in discovery, because Bertolino said you'd be getting this letter in discovery. Totally reasonable inference made by Pat Riley that he would have this letter to dissect and use and see as part of his case. But now they're blocking it. Let's talk about why. And let's also talk about what a motion for a protective order is as we look at this one together. When you object to a document like this being produced in evidence by your client, and you file a motion for protective order, which they have filed here, the purpose is to stop the court, or to get the court to stop them from getting this piece of documentation. We would call it evidence, but it doesn't come in a trial and is not relevant to this case. It's not a piece of evidence in this case. But you want to have the court stop them from getting this documentation, letter, video, whatever it may be, for a specific reason. A lot of times it's infringing on the privacy rights. It's not relevant. It's used to harass or hurt somebody. Those are the most common. We file these sometimes when insurance companies want to get our clients' OBGYN records or the birth records of their children when it has nothing to do with their case, or some kind of embarrassing record that doesn't have any relevance in their case, unless, of course, it's a lower back injury that has to do with certain things that you may tell your OBGYN or have to happen in a birth Did you have lower back pain? But sometimes they are so remote in time, they can be 50 years ago, and try to get records that are just to harass or hurt our client or delay the process or take more time and money than is necessary to actually continue the case going for what we are here for. I have not read this in its entirety. We're going to read it for the first time here together. I don't know what arguments they're making, but those are the most common ones, that it's going to invade on the privacy rights of the party that you're trying to gain these records on, or just to harass them or bother them or embarrass them. Those are the most common themes of protective orders in civil cases. So let's get through this one together. Defendants, Chris and Roberta Laundrie, by and through undersigned counsel, move for protective order pursuant to Florida Rule of Civil Procedure 1.280C for plaintiff's second request for production to Christopher and Roberta Laundrie, which requests a letter written by Roberta Laundrie to Brian Laundrie. In support thereof, defendants offer the following. So you may ask, why is it the second request for production? Why didn't they ask for this in the first one? Well, my guess is they vaguely asked for all documentation relevant to this case. This was not produced. So to be more specific, they asked for this specific letter. Number one, unquestionably, a trial court possesses broad discretion in overseeing discovery and protecting the parties that come before it. Upon proper application for good cause shown, the trial court may grant a protective order where justice requires. The rule is designated to protect a party or person from annoyance, embarrassment, oppression, or undue burden or expense. The burden to show good cause lies upon the party seeking the protective order, which means the defendant in this case. They have the burden to prove good cause is needed here for the judge to step in. The court may order, among other remedies, that the discovery may not be had, that certain matters not be inquired into, or that the scope of the discovery be limited to certain matters. Defendants seek a protective order from the court protecting them from producing a letter written by Roberta Laundrie to her son, Brian Laundrie, which is specifically requested by plaintiff's second request for production. So they got more specific, most likely. As the court is aware, this case arises out of the undeniably sad circumstance where defendant's son, Brian Laundrie, killed plaintiff's daughter, Gabby Petito, after which defendant's son took his own life. This has been a truly heartbreaking experience for both families, and it can't go understated with how sad this really is. The public who followed the case and the plaintiffs are likely curious about the letter because some of the language used makes it seem as though it's somehow related to Miss Petito's death. So they're invoking the media here. And that leads me to believe they think the contents of this letter are going to cause more problems in the media for the Laundrie family. However, Roberta Laundrie wrote this letter months before those events transpired. Well, you may ask, Peter, how's that possible? I thought Pat Riley said the letter was undated. And it was. But guess what? The person who wrote the letter would know when the letter was written and why the letter was written. Now, Pat Riley also said in his interview with JB that he is not going to take Roberta Laundrie's word for this or really much else. As every parent knows, your relationship with your children can have its periods of closeness and periods of distance. And we can assume a lot of this is coming straight from Roberta Laundrie. Roberta and Brian Laundrie shared a love of stories, and the language from the letter comes from stories and phrases they both would have recognized. The letter was Roberta's attempt to connect with her son and convey the strength of their relationship before he planned to leave home. That would make sense, and that would put it before all this happened. Roberta Laundrie never would have fathomed the events that would transpire between Brian and Gabby months later. At the time it was written, the letter was meant as a light-hearted reminder of the stories they shared together. In hindsight, the letter may appear unfortunately worded, but that was never its intention. So they're admitting that there's some language here that's going to be damning, but that it was not relevant to this. And I've heard just by, watching some interviews with Pat Riley that there was some mention of children's books and stuff in this letter that were kind of weird between Roberta Laundrie and her adult son. We'll see if there's any more of that in here. Therein lies the problem with this letter. Its origin has no relation to this case. Its origin having no relation to this case doesn't mean that it can't be relevant to this case now. What you say before an event happens and what letters you write before an event happens can absolutely be relevant even if you did not intend for it to relate to this event. But its publishing is embarrassing and most prejudicial to Roberta Laundrie. Well, duh, all evidence against them is going to be prejudicial. Now, why is it embarrassing? That's a question that remains open. If the letter is produced in discovery, it will undoubtedly be made available to the media at some point. Yeah. But they could also file a motion to seal and keep it under seal. The plaintiff would, I'm sure, object to that. The media is already aware of Roberta Laundrie's letter through the plaintiff's filing and letter to counsel in support of their motion to compel and interviews made by plaintiff's counsel. And there has already been significant media commentary just about the mere reference of it because it said on the outside of the envelope, burn after reading. Discovery is usually permitted only on matters that are relevant or reasonably calculated to lead to the discovery of admissible evidence. That's like the most common objection in this discovery. Just FYI, is it's not relevant or not reasonably calculated to lead to discoverable material. That's like the canned objection. Okay, and then there's some case law that says that. A lot of case law that says that can't be utilized to explore all the minute details of a controversy. It can't be overly broad. It can't be a fishing expedition, et cetera, et cetera. The plaintiff's cause of action is one for intentional infliction of emotional distress. The elements are 1, deliberate or reckless infliction of mental suffering; 2, outrageous conduct; 3, the conduct caused the emotional distress; and 4, the distress was severe. The letter was not written to the plaintiffs or published in such a way that they could have seen it during the relevant period of time alleged in the second amended complaint. Therefore, it could not have caused them emotional distress. And I will pause here. While that may be true, a huge part of this case is, what did the Laundries know? What did they know and what did they do? And how did what they do or not do, based on what they knew, affect the Petitos? It may sound convoluted. And while I think, we've talked about the issues I have with this case, with this cause of action, with them bringing Bertolino in, every piece of evidence does not have to directly go to an element of the cause of action. Their knowledge, what they did, why they did it, also comes into play, and it doesn't necessarily have to connect individually with an element. Therefore, it could not have caused them emotional distress. Records that did not result in specific acts or conduct alleged in the second amended complaint are irrelevant to the cause of action for intentional infliction of emotional distress. I disagree there. Furthermore, as Roberta Laundrie did not intend for anyone other than Brian to view the letter, she could not have deliberately or recklessly intended the plaintiffs to experience distress by writing it. That doesn't make it irrelevant, right? And here's what we're saying. I'm not saying, just to be clear, I'm not saying this letter is going to come in at trial. I don't even know what's in the letter. I'm not saying this letter is going to be a key piece of evidence in winning or losing this case. What I'm saying is, based on the broad definition, the incredibly broad definition of discovery here in Florida, these arguments are not convincing to make it so that this letter falls outside that very broad definition of what's discoverable. But we're going to keep reading because there may be more. Furthermore, as Roberta Laundrie did not intend for anyone, I already read that, as such information would not support plaintiff's claim, and we're just going to take your word for it. At the very least, we need to have an in-camera inspection of this or show the judge what this letter actually says so the judge can make this decision. The only purpose the letter could possibly serve is to embarrass Roberta Laundrie. That is not an appropriate use of discovery. I agree with that. If the sole purpose is really to embarrass her, that is not the appropriate use of discovery. But who is to make that determination? Usually not the party with the letter that would be embarrassed. There would have to be some agreement with the court, with the plaintiff, an in-camera review. What does the letter actually show? Usually you would have to tell the plaintiff or show the plaintiff what the letter actually says before anybody can make arguments, because it could say something incredibly important that the plaintiff would have been like, if I would have known that, judge, I would have made that argument and this would have come in. So in order for it to be fair, everybody has to know what that letter says. Now, there should be a motion to seal, a confidentiality agreement. What you can do as part of this process is, all the time, we have confidentiality agreements that we sign with the other side before they produce certain discovery with us. We just signed one yesterday. So that can be done. An in-camera review under seal where nobody can talk about it, but they can at least see the content and make their arguments in front of the judge. And then the judge can make the decision either to not allow it and grant this motion for protective order, allow it and just let it be open, or allow it and let it be sealed and let a confidentiality agreement not allow anybody to talk about it publicly, not allowed to go to the media, but can still be used as part of the case. Those are kind of the options we have here. The scope of discovery should be limited to the time period of August 27th through September 19th. Totally disagree with that. The time period between the death of Miss Petito and when her body was found at the alleged as alleged in the Second Amended complaint, and further limited to the information related to the outward actions or comments of the defendants during the time period. The letter predated that time frame, makes no reference to the plaintiffs, and the plaintiffs did not see the letter such that it could cause them distress. So here's why I disagree with that. If you wrote a letter that said, if you ever found a dead body, I'll help you bury it, I'll help you get rid of it, I think that's relevant. Now, does it actually prove they did that? No, but I think it would be relevant to the jury, especially if the defendants were going to make some argument like they would have never done something like this, like we just heard in another trial. So this stuff can be relevant. Will it come in as evidence? I don't know. But could it potentially lead to discoverable material? Absolutely, yes. Defendants during that time period, the letter predated the time frame, makes no reference to the plaintiff, and the plaintiffs did not see the letter such that it could cause them distress. The defendants respectfully request the court to protect Christopher Laundrie and Roberta Laundrie from producing the letter. Such an order would not prevent the plaintiffs from inquiring as to the claims taken by the defendants and public comments made by them on their behalf. Defendants suggest that they produce the letter to the court for an in-camera review. There we go. So the court can analyze the letter along with Roberta Laundrie's affidavit. And let's hear the context she gives to this letter. Affidavit of Roberta Laundrie in support of motion for protective order. I, Roberta Laundrie, am a defendant in the above styled cause, and I do hereby swear or affirm that I fully understand the meaning of the terms of this affidavit. I wrote the letter requested by plaintiff's second request for production. I wrote the letter to my son, Brian Laundrie, on or about the end of May 2021. Pretty convenient and pretty close to the time all this happened. Although I do not know the exact date I wrote the letter, I do know that I wrote it and gave it to Brian before Brian and Gabby left Florida for New York, which was on June 2nd, 2021. Brian and Gabby went from Florida to New York before they went out west. So here's what's interesting. And here's what I would argue if I was the plaintiff in this case. So you wrote it right before they left. Did you write it because you and Brian were having conversations about how he was angry at Gabby, about how he wanted to hurt Gabby, about if he did hurt her, what you would do to help him? Because all of that makes this very relevant. And the timing being so close to it, again, I haven't read all this. So, I haven't really made up my mind as to how I feel, but obviously you see which direction I'm going in. The purpose of the letter was to reach out to Brian while he and I were experiencing a difficult period in our relationship. Brian and I always had a very open and communicative relationship. And in the months prior to the trip, our relationship had become strained. Why? Was he telling you he wanted to hurt Gabby? What were there negative things going on? And you'll see why it's so important to have this letter as a plaintiff's lawyer to cross-examine Roberta Laundrie and ask her these questions. That's what could be discoverable material. This is prototypical. This letter could reasonably lead to discoverable material about what you knew and what you did and why that they are claiming fits into this intentional infliction of emotional stress, which I'm not so sure about that. But if the court's going to allow this cause of action to go forward, it seems like this is absolutely discoverable. Brian and I shared a love of stories, and some of the language in the letter was using similar phrases to describe the depth of a mother's love. Now, listen, anything's going to be embarrassing between, a mother and a son, or some private letter getting out there. You're going to feel embarrassed. It's going to feel harassing, but you have to weigh that on whether or not it's discoverable. And luckily, lawmakers and lawyers have thought about this. So we put rules in place, and where I'm leaning as to what is appropriate here is file it under seal, confidentiality agreement, in-camera review, but it is discoverable. And Petito's lawyers are absolutely allowed to ask both Laundrie parents about this in their deposition. That's what I think the fair outcome of this should be based on what I'm hearing so far. Two books that come to mind are Runaway Bunny and Little Bear. I haven't read either. In addition, Gabby had given Brian a book called Burn After Writing, which right there, we're referencing Gabby, right? Which contains printed questions to which the reader responds by writing their answers on the page. The back of the book instructs the reader to create a secret book and then destroy by burn after writing. The bottom of the back cover says, write, burn, repeat. Brian, Gabby, and I often joked about this book and the importance of being able to express yourself. If you were embarrassed or simply did not want anyone to know your thoughts or feelings, then the book offered the perfect solution by telling you to burn it. This is where my message to Brian came from, and I wrote on the cover of the letter for Brian to burn after reading. The other issue with this, and with her explanation, is the other two people that were in this inside joke, because Chris Laundrie wasn't even involved here, But the other two people that were involved both can't confirm or deny whether or not what she's telling is true. In short, I was trying to connect with Brian and repair our relationship as he was planning to leave home, and I had hoped this letter would remind him of how much I loved him. I don't doubt that. I don't doubt a mother's love ever. But we're talking about whether or not it could potentially be relevant or could potentially lead to other discoverable material. Sometimes we get, let's just say, an employee file. That employee file may not be evidence, but something in that employee file could lead us to something that is relevant to our case. That would make that employee file discoverable. That's the whole point of this discussion. There were some other phrases that I used in the letter which are not found in the books I shared with Brian as a child. However, these phrases were common enough in our circle of friends and family to describe who you could turn to in the most troubling of times. Who? Who would be able to tell us whether or not this is true or false? Can we get other witnesses' names that may need to be deposed? While I use words that seem to have a connection with Brian's actions and his taking of Gabby's life, so she's admitting, she agrees with that he did that, right? They're not trying to argue for him. They're not trying to say, no, we still don't believe he didn't do it. They obviously believe those letters written by Brian are true and accurate, and he did do this. I don't know. I mean, if I didn't see Brian write it or I wasn't absolutely positive, I'd probably be like, I still don't know what happened. I can't believe my son would do that, right? Like you would think about your son that way. People are still thinking that way about Alec Murdaugh. But she's seemingly admitting it, which does she know more than the letters would say, which I would now use. This affidavit becomes an exhibit to her deposition. Also, just FYI, your words can always be used to impeach you or to ask you questions about, was this true, false? Where did you get this information? Expand on this during a civil deposition. And again, she's able to say all this without her Fifth Amendment right being implicated. So again, I would also use the fact that she's now, Judge, using the Fifth Amendment as a sword and a shield, which she's already argued. So she's going to get her words out and her statements out there when they help her, but when they might hurt her, then she's going to plead the Fifth. I would absolutely use this as an exhibit to a future motion and as an exhibit to her deposition. So you agree Brian did this. Did he tell you he did it? When did you first find out? All those questions. I never would have fathomed the events that unfolded months later between Brian and Gabby would reflect the words in my letter. The words in the letter could never have been a comment on this tragic situation as they were written so many months before. My words to Brian were meant to convey my love and support for my son through a lighthearted and quirky reminder that my love for him was not diminished and could not be shaken by the miles of separation we would soon be faced with, or by the horrible crimes you committed. I mean, I think that it's possible that they could argue that. Now, if they can prove when it was written, I absolutely don't think the Petito family or their lawyer should be allowed to argue to a jury that this was in reference to Gabby Petito. If somehow they can prove this was written in May, he can't say they must have found out what happened to Gabby. They wrote this letter that they would love him no matter how horrible what he did was. They would help him, get rid of a body or whatever. They can't make that argument, in my opinion, if they can actually prove when this letter was written. Although a few of the words in the letter are being quoted by others as having a connection to this case, all of the words taken together and in the context of the reason the letter was written show that there is no connection. Then produce it. Your lawyer can argue that to a jury. If it's clear that the context and all the words of the letter, then that's the rule of completion. Don't let them misquote you or take quotes out of context. Put the whole letter in. In addition, there has been some speculation that this letter was in Brian's possession or in his backpack when he died, insinuating that I gave it to him as he left my home on September 13th, 2021. So there's another admission. We know now for a fact that Brian left the Laundrie home on September 13th of 2021. But that is not true because the FBI had the letter in their possession and questioned members of the family about it prior to October 20th, 2021, when my husband and I found Brian's remains in the reserve. Okay, so they had it before Brian was found. I repeat that the letter I wrote to Brian before he left with Gabby for their fateful trip was nothing more than a private communication between myself and my son, and I never expected anyone else to read it. But if the judge is going to let statements like this come out and allow this case to go forward as intentional infliction of emotional distress, it makes some of these private communications public. We've seen private text messages very public in trials between family members if they are relevant to the case and the situation. Again, you don't want to embarrass them. You don't want to talk about you cried about your girlfriend last night, or, I know you were crying and I kissed your boo-boo on your toe or something embarrassing like that that has nothing to do with the case. We're not going to put that out there for the media to just salivate over or to make a big deal about. But if it actually has a connection to the case, then it's going to come out. In some way, I did not want in every way, probably, I did not want anyone else to read it, as I know it is not the type of letter a mother writes to her adult son, and I did not want to embarrass Brian. That's weird. I mean, that's a weird sentence. That is why I wrote burn after reading on the envelope, and I knew that Brian would know what that meant. I am now appreciative that he actually kept it. I mean, you can't imagine the feelings and thoughts that go when she loses a child like that. So I understand what she's saying there. But just because you wanted him to burn it, just because you don't want to embarrass him, does not mean that it's not relevant to a case that the court has allowed to go forward. And that's the point. Whether I agree with that decision or not, it's going forward. It is a civil lawsuit. This seems very discoverable to me, but it also seems like something that, in an abundance of caution, we should seal and keep confidential at this point and not let the media get a hold of. I mean, that's just my opinion. The media can file their First Amendment arguments, but that's how I would do it if I was the judge. I think that this is discoverable. I think that the Petito family should get it, whether it's in camera, under seal, confidentiality, whatever, not be allowed to talk about it in the media or discuss the contents of the letter at this point, maybe in the future if they become open, or let's at least see if after more discovery is done, this is actually going to be a relevant and admissible piece of evidence used at trial. Because if it's not, then definitely keep it sealed and confidential forever if it does just lead to other discoverable material. So I think there's a lot still up in the air with this case, but it's a very interesting argument, interesting discussion on the motion for protective order, on how that affidavit affects their Fifth Amendment right, whether or not it's going to be used at their depot, what questions can be asked, all very interesting context that we can still learn from in this case. Let me know what questions you have in the comments, and let me know if you're still following this case. Appreciate everybody joining me. Until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.